Republic Act No. 8049. An act regulating hazing, and other forms of initiation rites in fraternities, sororities, and other organizations, and providing penalties therefor. Section 1. Hazing, as used in this act, is an initiation rite or practice, as a prerequisite for admission into membership in a fraternity, sorority, or organization, by placing the recruit, neophyte, or applicant in some embarrassing or humiliating situations, such as forcing him to do menial, silly, foolish, and other similar tasks or activities, or otherwise subjecting him to physical or psychological suffering or injury. The term organization shall include any club, or the armed forces of the Philippines, Philippine National Police, Philippine Military Academy, or Officer and Cadet Corps of the Citizens Military Training, and Citizens Army Training. The physical, mental, and psychological testing and training procedure, and practices to determine and enhance the physical, mental, and psychological fitness of prospective regular members of the Armed Forces of the Philippines, and the Philippine National Police, as approved by the Secretary of National Defense, and the National Police Commission duly recommended by the Chief of Staff, Armed Forces of the Philippines, and the Director General of the Philippine National Police, shall not be considered as hazing for the purposes of this Act. Section 2. No hazing or initiation rites in any form or manner by a fraternity, sorority, or organization, shall be allowed without prior written notice to the school authorities, or head of organization 7 days before the conduct of such initiation. The written notice shall indicate the period of the initiation activities, which shall not exceed 3 days, shall include the names of those to be subjected to such activities, and shall further contain an undertaking that no physical violence be employed by anybody during such initiation rites. Section 3. The head of the school, or organization, or their representatives, must assign at least 2 representatives of the school or organization, as the case may be, to be present during the initiation. It is the duty of such representative to see to it that no physical harm of any kind shall be inflicted upon a recruit, neophyte, or applicant. Section 4. If the person subjected to hazing, or other forms of initiation rites, suffers any physical injury, or dies as a result thereof, the officers and members of the fraternity, sorority, or organization, who actually participated in the infliction of physical harm, shall be liable as principals. The person or persons who participated in the hazing shall suffer 1. The penalty of reclusion perpetua, or life imprisonment, if death, rape, sodomy, or mutilation results therefrom. 2. The penalty of reclusion temporal in its maximum period, that is, 17 years, 4 months and 1 day to 20 years, if in consequence of the hazing, the victim shall become insane, imbecile, impotent, or blind. 3. The penalty of reclusion temporal in its medium period, that is, 14 years, 8 months and 1 day to 17 years and 4 months, if in consequence of the hazing, the victim shall have lost the use of speech, or the power to hear, or to smell, or shall have lost an eye, a hand, a foot, an arm, or a leg, or shall have lost the use of any such member, shall have become incapacitated for the activity or work in which he was habitually engaged. 4. The penalty of reclusion temporal in its minimum period, that is, 12 years and 1 day to 14 years and 8 months, if in consequence of the hazing, the victim shall become deformed, or shall have lost any other part of his body, or shall have lost the use thereof, or shall have been ill, or incapacitated for the performance on the activity or work in which he was habitually engaged, for a period of more than 90 days. 5. The penalty of prison mere in its maximum period, that is, 10 years and 1 day to 12 years, if in consequence of the hazing, the victim shall have been ill, or incapacitated for the performance on the activity or work in which he was habitually engaged, for a period of more than 30 days. 6. The penalty of prison mere in its medium period, that is, 8 years and 1 day to 10 years, if in consequence of the hazing, the victim shall have been ill, or incapacitated for the performance on the activity or work in which he was habitually engaged, for a period of 10 days or more, or that the injury sustained shall require medical assistance for the same period. 7. The penalty of prison may in its minimum period, that is, 6 years and 1 day to 8 years, if in consequence of the hazing, the victim shall have been ill, or incapacitated for the performance on the activity or work in which he was habitually engaged, from 1 to 9 days, or that the injury sustained shall require medical assistance for the same period. 8. The penalty of prison correctional in its maximum period, that is, 4 years, 2 months and 1 day to 6 years, if in consequence of the hazing, the victim sustained physical injuries, which do not prevent him from engaging in his habitual activity or work, nor require medical attendance. The responsible officials of the school, or of the police, military, or citizens' army training organization, may impose the appropriate administrative sanctions on the person, or the persons charged under this provision, even before their conviction. The maximum penalty herein provided, shall be imposed in any of the following instances. A. When the recruitment is accompanied by force, violence, threat, intimidation, or deceit on the person of the recruit, who refuses to join. B. When the recruit, neophyte, or applicant initially consents to join, but upon learning that hazing will be committed on his person, is prevented from quitting. C. When the recruit, neophyte, or applicant having undergone hazing, is prevented from reporting the unlawful act to his parents, or guardians, to the proper school authorities, or to the police authorities, through force, violence, threat, or intimidation. D. When the hazing is committed outside of the school or institution. Or, E. When the victim is below 12 years of age at the time of the hazing. The owner of the place where hazing is conducted, shall be liable as an accomplice, when he has actual knowledge of the hazing conducted therein, but failed to take any action to prevent the same from occurring. If the hazing is held in the home of one of the officers or members of the fraternity, group, or organization, the parents shall be held liable, as principals, when they have actual knowledge of the hazing conducted therein, but failed to take any action to prevent the same from occurring. The school authorities, including faculty members, who consent to the hazing, or who have actual knowledge thereof, but failed to take any action to prevent the same from occurring, shall be punished, as accomplices, for the acts of hazing committed by the perpetrators. The officers, former officers, or alumni of the organization, group, fraternity, or sorority, who actually planned the hazing, although not present when the acts constituting the hazing were committed, shall be liable as principals. A fraternity or sorority's advisor, who is present when the acts constituting the hazing were committed, and failed to take action to prevent the same from occurring, shall be liable as principal. The presence of any person during the hazing is prima facie evidence of participation therein as principal, unless he prevented the commission of the acts punishable herein. Any person charged under this provision shall not be entitled to the mitigating circumstance that there was no intention to commit so grave a wrong. This section shall apply to the president, manager, director, or other responsible officer of a corporation engaged in hazing, as a requirement for employment, in the manner provided herein. Section 5. If any provision, or part of this Act, is declared invalid or unconstitutional, the other parts or provisions thereof shall remain valid and effective. Section 6. All laws, orders, rules or regulations which are inconsistent with, or contrary to the provisions of this Act, are hereby amended or repealed accordingly. Section 7. This Act shall take effect 15 calendar days after its publication in at least 2 national newspapers of general circulation. End of Republic Act No. 8049. Prepared by Taunton of Philim Band, who always keeps my feet above his. Thank you for the smile.